Hello and welcome. I am Ronald Onyango, a solicitor and migration consultant. In today's video, we'll explore the recent updates and changes in the UK immigration laws as of February 2025. I will also mention important rules since January 2024, which remains relevant up to 2025. Staying informed is crucial whether you are an employer, a migrant, or someone planning to move to the UK. Make sure you stay till the end, as every single aspect of the update matters and may affect you. Let's now dive into the developments and see how they impact on you. The first update is on UK Student Dependent Visa rules. New restrictions on students' visas impacting students' ability to bring family members to the UK as dependents as of 1st of January 2024. The UK Home Office has enforced new rules impacting the ability of students to bring dependents. This was announced in July 2023 and aims to limit the number of dependents accompanying international students. The 5 main takeaways on students and dependent visas are as follows. As of January 2024, only PhD students, postgraduate researchers, and government-sponsored students are able to bring dependents to the UK. Existing students and dependents who started their courses before January 2024 and their dependents are not affected by the changes and can apply for extensions of the visas under the previous rules. Visa extension dependents are able to extend their visas provided the main applicant qualifies under the new rules or switches to a graduate visa. Switching to a work visa, dependents are allowed to apply for skilled worker visas to change status provided they qualify for the job and meet the salary, sponsorship and the English language requirements. Restrictions for dependents. Parents and of student visa holders cannot switch to a skilled worker visa, and new dependents are generally not allowed on graduate visas. And not on the transition stages. Requirements that students on work visas, specifically students participating in PhD or postgraduate or research programs, are allowed to bring dependents to the UK. Under the new rules, students must complete their studies and secure a job with a start date after the graduation to switch to a work visa, such as a skilled worker visa. Furthermore, a PhD student must finish at least 24 months of their program before they can embark to apply for the transition. There are changes to the British Citizenship Eligibility. New restrictions for refugees arriving via irregular routes as of February 10, 2025. The Home Office has implemented new rules affecting the refugees who enter the UK through irregular means such as small boats or concealed in vehicles. These individuals will now be barred from obtaining British citizenship regardless of how much time has passed since their arrival in the UK. This aims to deter dangerous journeys and unauthorized entries into the UK. There are legal challenges and criticisms that have arisen from this, which have been sparked, and challenges from the various quarters. It's notable that a case involving a 21-year-old Afghan refugee who arrived in the UK at 14 was on the path to citizenship. The new policy has disrupted his plans, leading to a legal action against the Home Office. Critics argue that policy misinterprets the British Nationality and Act, violates human rights, potentially creating a class of residents who are unable to integrate into the British society. With regards to electronic travel authorization, the ETA, the Scheme Expansion Mandatory Program for non-visa nationals, The UK Electronic Travel Authorization (ETA) system is expanding. As of January 8, 2025, non-European nationals who previously did not need a visa will now be required to obtain an ETA before travelling to transitioning through UK airports. This change aims to enhance border security and streamline entry processes. Upcoming changes for European nationals starting March 5th, 2025. European nationals will be able to apply for the ETA, which will become mandatory for travel from the April 2nd, 2025. The ETA document is valid for multiple entries over 2 years and allows one to stay on an uncapped period for up to 6 months per visit. Travellers are also encouraged to apply well in advance to avoid potential delays. Sponsorship cost regulations for employers. There is a prohibition on passing sponsorship costs to employers effective December 31st, 2024. The UK government has prohibited employers from passing certain sponsorship costs to sponsored workers. This includes fees for sponsorship license applications and certificates of sponsorships. The policy aims to prevent exploitation and reduce work-related debt among migrant employees. Non-compliance can lead to severe penalties, including the revocation of their sponsor license. Recommended actions for employers arising from this policy change include: the employer should 1. Review and update policies ensuring internal policies align with the new regulations. They can also amend employment contracts, remove any clauses that require employees to bear prohibited costs. Budget adjustments accounting for these costs in financial planning to ensure compliance. Changes on EU settlement scheme, EU SSS status. Automation. There's automation upgrade from the pre-settled status with effect from late January 2025. The Home Office will automatically convert eligible EU settlement scheme pre-settled status holders to settled status. This initiative removes the need for individuals to apply separately for permanent settlement, hence simplifying the process for many residents. The implications for EU nationals. This change benefits EU nationals who have maintained continuous residence in the UK, ensuring their rights are preserved without additional administrative burden and extra costs, including legal fees, etc. However, those without sufficient evidence of continuous residence may still need to apply manually. It's essential to stay informed and ensure all personal records are up to date. Political debates and proposed policies changes. Conservative Party has proposed immigration policies as announced by their leader Kemi Badenoch. The Conservative Party has proposed 3 significant changes to immigration policies, including one that extending the qualifying period for indefinite leave to remain from 5 to 10 years. Secondly, barring indefinite leave to remain for migrants using public benefits, hence preventing those who have claimed benefits or use social housing from obtaining permanent residence. And thirdly, increasing the waiting times for citizenship applications, requiring migrants to wait for 5 years after obtaining indefinite leave to remain before applying for British citizenship. These proposals aim to reduce permanent residence granted and address the public perception and concerns that on immigration. However, they have sparked debates about fairness, integration, and the potential impact on communities in the country. Labour government stance has been different and has taken a different step by balancing border security with humanitarian considerations on this. While repealing certain policies of the previous administration, they have introduced measures which deter illegal immigration and human trafficking. The political landscape remains dynamic, with ongoing discussions about the best approaches to immigration and asylum policies. In conclusion, these developments reflect the UK's evolving approach to immigration in 2025. Whether you are directly affected or simply interested in immigration policies, staying informed is essential. If you have any questions or need personalized guidance and advice on any of the issues mentioned, feel free to book a consultation with me, Ronald Onyango, and I'm here to help you navigate these complex changes and offer you guidance accordingly. For more updates and expert insights, subscribe to the channel as I assure you of regular and very important immigration updates. Don't forget to like and share the video. See you next time. Thank you.